have one question. So, hello, everybody. Before we get started, Craig, there was a question in the chat room.
Okay.
What is the number to dial in to hear?
Okay, I will get that. I will put that
We'll
in the
put
chat.
that in, or whomever asked for that
Okay, I
as
will
we
do
get
that.
started.
Yep.
So, good afternoon. My name is Kathleen Borain, and I serve as the Maryland Insurance Commissioner. And I'd like to welcome everyone today to this virtual training session, which is entitled Provider Panels, the Credentialing Process. This session is designed to help providers better understand the credentialing process. And today we will first review the pertinent provisions of the law. 2, provide an overview of the application process. 3, explain the particular timeframes that providers can expect when going through that process. 4, explain prohibited and permitted reasons for denials or terminations of credentialing. And finally, talk about the role that the Maryland Insurance Administration plays in this process, including your ability as a provider who believes you are encountering unlengthy delays or unreasonable requests, your ability to come to us with your questions, your concerns, and your complaints so that we can help you to unbundle and unravel what's going on and see if we can't get things moving for you. Some of you will recall that back in July, we held a virtual town hall, the purpose of which was to hear about some of the challenges that healthcare providers had shared with us about what they experience when they're attempting to become credentialed to participate in the provider networks used by commercial insurance carriers. We all know that having insurance isn't enough if there are not sufficient providers in the network to meet patient needs. And therefore, ensuring that carriers have adequate networks is very important to the Maryland Insurance Administration. During the virtual town hall, we learned from provider representatives and consumer advocates about some of the areas where, in their providers' attempt to join carrier networks, they felt that they were encountering unreasonable barriers or unreasonable delays during the credentialing process. Now, we have done some of our own analysis, investigation, and review to look more deeply into the intricacies of the credentialing process. And we felt that one of the ways in which we could most help the provider community, at least at this juncture, is to be an advocate and an educational resource to you in helping you to understand what you should expect, what the law requires, and then where to come, that would be to us, when you are encountering difficulties, barriers, and unreasonable delays. So that's really what this session is all about. It's helping to empower you with knowledge about how to go through this process and how to get to us when the process is not working the way it should be working. So as we get started, let me just take a second to introduce the MIA staff who are on today's session, and then I'll cover just a few housekeeping measures. So first, let me introduce you to David Cooney, who is the MIA's Associate Commissioner for Life and Health.
Good afternoon, everyone.
And then Joy Hatchett, who is the Associate Commissioner for Consumer Education and Advocacy.
Hello.
And Mary Quay, who is the Chief of Life and Health Complaints, and Mary will be leading today's session.
Good afternoon.
And you've met Craig I, who is our Director of Communications.
Hello and welcome.
So now a few housekeeping items. This virtual webinar is being held via the Zoom webinar platform and is being recorded. The video and sound recording will be made available on the MIA's website within the next few days. If you have questions as we go through today's webinar, just let us know in the chat function and we will do our best to answer as many questions as we can today. And obviously you will know how to reach out to us if you have questions either that we don't get to or are probably more appropriate for a one-on-one conversation. We certainly hope that you find today's session informative and useful, and I'm going to ask every one of you a personal favor. When you finish today's webinar, I would very much appreciate it if you would send a short email to Craig to let him know whether or not this was useful and valuable to you, and whether this is a mode of education that you find useful. We want to make sure that as we're delivering content and delivering education, that we're delivering it in a way that is useful and helpful and accessible. And if you have thoughts and suggestions about how we could do a better job at that and serve you in a better way, I really want to know that. So Craig, I will put his contact information in the chat function, and you are not only welcome to, but would be deeply appreciated by me if you would give us that kind of feedback so that we can learn to be better at the job that we do. So with that, I am now going to turn this over to Mary and my team to begin the instructional section.
Thank you, Commissioner. Okay, if we can have the first slide, please. Okay, as Kathleen said, I am Mary Quay. I am the Chief of Life and Health Complaints at the MIA. That means I manage the complaints unit that gets complaints about life and health insurance, including complaints from providers about the credentialing process. Next slide, please. So Kathleen already mentioned what we're going to be going over today, and this is our agenda. I do want to say that by credentialing, we mean the process by which a carrier decides whether to accept a provider for the network. And so that typically involves getting an application, verifying references, education, board certification, et cetera. It does not include the contracting process. So the timeframes that we're talking about do not include the timeframes to negotiate a final fee schedule. But we do look at the other things about the application, the timeframes, reasons that they may or may not deny an application or terminate a provider, and what happens in a few special situations. Next slide, please. Okay, so the Maryland Insurance Administration, we call ourselves the MIA, is the state agency that regulates insurance in Maryland. And that includes various activities, including licensing insurers, and that involves looking at solvency and making sure that they ought to have a license to conduct insurance business, and also looking for any entities that are out there who are doing insurance business without a license. We also license producers who are insurance agents or brokers to make sure that they are honest and have some fundamental knowledge. We look at their business practices. That's usually done through our market conduct unit for insurance companies, and they look at what companies do on a wide scale basis. We have a unit that looks at solvency to make sure insurance companies can pay claims. One of the things people often don't know about is that insurance policies, before they're sold in the state, the forms that are used have to be approved by the MIA to make sure that they comply with state law. We also review the insurance premium rates, and that is done by actuaries to make sure that the rates comply with the law. And then we have a fraud unit that can look at allegations of fraud. Next slide, please. So what my unit does, and one of our big activities, is that we look at complaints as part of the regulatory process. And here are some things that people may complain about. And as I said, we can also look at whether a carrier is complying with the laws around credentialing. We accept complaints from members of the public, from healthcare providers. We get some from attorneys, but we're here to look at whether companies are complying with the law in specific cases. But when we get complaints, we also track that data so we can see if there's a problem and we need to look at their business practices in greater detail. So if you file a complaint, we can look at the complaint to see if the company followed the law with your issue, but also we get data about whether the company is complying with the law for everybody. So next slide, please. Okay, so the law we're going to be talking about today is section 15.112 of the insurance article. And this law, I've been using the term carriers. And carriers is an inclusive term that we use to mean all types of entities that provide insurance or health plans that are like insurance. And so that's insurance companies, HMOs, nonprofit health service plans. The best known of those is going to be Care First. Dental plan organizations are companies that only provide dental plans. And then the final category is an entity that arranges a provider panel on behalf of a carrier. And so that's going to be a company that may put together a provider panel that is leased to different companies. That's pretty common, especially for, say, mental health or sometimes for physical therapy. And so they are also considered carriers under this law. Next slide, please. All right, so if you're a provider, do you get the benefits of this law? Well, it defines a provider to include a healthcare practitioner or a group of healthcare practitioners. And so what that means is a practitioner is an individual. And then a group of healthcare practitioners would be a group practice. But it's not a facility. And then the law gives the requirements for the application process. And I will say 15.112 is a lengthy law. And it includes some other things as well related to provider networks, but we're going to focus in mostly on the ones related to credentialing today. So next slide, please. Okay, so section 15.112.1, that's another law here that says that a carrier has to accept the uniform credentialing form as the sole application from a healthcare provider to become credentialed. So if you're a practitioner or a group practice and you want to become credentialed, then you ought to be able to fill out this one form and use it for different carriers. And we issued a bulletin to designate the CAQH form as the uniform credentialing form. For health plans, dental plans have a separate credentialing form. And I know that we previously did one of these webinars and I got a lot of questions about dental plan credentialing. And if you have specific dental plan questions, please contact me after the webinar. I'll be happy to look into those for you. So next slide, please. I saw a question in the chat about facilities. We will be touching a bit on facilities, but the law that we're discussing today does not include facilities. So it will not be the primary focus. Okay, timeframes. Everyone that we hear from feels that the carrier is taking too long to process an application. That would be a huge percentage of the complaints that we get about credentialing, at least currently. So you should get an application if you request one. But again, most carriers are using and should be using the CAQH form. If the carrier gets an incomplete application, the carrier has 10 days to send a notice telling you what you need to provide. Once the carrier receives a complete application, it is then 30 days to send you a notice of the intent to continue to process the application or to reject the provider. Typically at this point, what you're going to see is a rejection because the network is full. And then if the carrier proceeds with credentialing, it has 120 days from the date of the notice. And so that's 150 days potentially from the date of receiving the application. And then the notice of whether they are accepting or rejecting the provider has to be sent in writing. Next slide, please. Okay, some of these are reasons why providers worry a lot about being rejected or terminated from a provider panel. Carriers may not reject or terminate providers based on gender, race, age, religion, national origin, or a protected category under the Americans with Disabilities Act. And that's pretty much what you would expect. Those are the discrimination laws we're used to seeing. Okay, I had a question about delegated providers. If that means like hospitals that then credential physicians or providers there. If it means entities like, oh, say, a mental health entity that provides a panel, it would apply. If there's more detail on what you'd like to know there, that would be helpful. Okay, so other reasons that a carrier may not reject or terminate a provider: appeals based on medical necessity, and appeals or complaints through a process established by the carrier for that purpose. So we hear a lot from providers about being afraid to file complaints because they fear retaliation. And that should not happen. And I have not heard anecdotal reports that it does happen. But the law is clear that this is also about filing complaints through a process and also based on medical necessity. So a carrier could terminate a provider for, calling the network liaison, every day to complain about various aspects of the contract or claims processing. You do want to go through the proper channels and file an appeal or a grievance, or when you file a complaint with the MIA. Okay, and a relatively new part of the law is that a carrier may not limit the number of behavioral health providers at a healthcare facility that may be credentialed. So next slide, please. Okay, reasons that a carrier may deny participation. And that, as I referred to already, a common one is a full network. Carriers may have different health plans with different networks, and some health plans have a plan that has a very wide network, and some have very narrow networks. And so a narrow network plan may decide to terminate providers or deny providers more often because they are full. However, if you already have a contract, the carrier can terminate it for any reason that is not prohibited with 90 days written notice to the provider. And a carrier may also terminate a provider without advance notice for fraud, patient abuse, incompetence, or loss of license status. And so licensure status would include a suspension, probation, as well as termination of a license. Next slide, please. Okay, this is a situation where we get a few complaints every year. Section 15112 of the insurance article has very specific details about what the provider group needs to send in. However, if a practitioner is employed by a group practice and the group practice is already participating and the practitioner has applied for credentialing and the carrier intends to continue to process the application. So that means that the provider has applied and the carrier has sent that 30-day notice that they will intend to continue to process the application. And then the practitioner has a valid license and is either credentialed by a hospital or has professional liability insurance. And so in all of these, if all of these criteria are met, and if I can have the next slide, please. Then the carrier has to pay the group practice at the participating rate for the practitioner who has already applied to be credentialed and added to the network. And that has to be paid from the date that the notice was sent of the intent to continue to process the application and until they have accepted or rejected the application. And so for members, that is as if the practitioner is already participating. Next slide, please. Okay, now if a group practice hires a provider who is not credentialed, patients have to be notified. And so this is notice that the practice has to give in the situation we've been talking about, I've been talking about, and that is that the patients need to be aware that the provider is not participating, but has applied to become participating, and that it will be covered as participating. And a specific question about if a provider is sanctioned and then the license is reinstated. And does the insurance carrier have to re-credential the provider? And I would assume that yes, if the participation in the contract has been terminated, then yes, most carriers will need to re-credential the provider. Next slide, please. Okay, what if a practitioner is already credentialed and moves to a different practice? And again, this is something where the law has some pretty specific requirements about what to send in. But the provider or practitioner should not have to go through credentialing again. And this is where the practitioner is moving to a new employer, changing tax ID numbers. Next slide, please. Okay, the law has very specific things that need to be sent to the carrier, and they are listed here. And it should be sent in at least 45 days before the effective date of the change. And then the carrier has 30 business days to acknowledge receipt. However, as I said, the carrier cannot require the practitioner to go through credentialing again. And so this is something people should also be aware of who run a group practice about hiring, whether you need to know whether or not someone is already credentialed and can be added right away, or if you're looking at the other situation where you're adding someone who is not credentialed to a participating group practice. Next slide, please. Okay, this is another pretty common situation where a practitioner may be credentialed and participate with a group practice or at a specific office, but also has a separate office where he or she is not participating. And so this would be, again, if a doctor is part of a group practice and then also has a separate office. And in this case, the provider needs to notify the patient that the provider is not participating at that office and what the charges will be. So next slide, please. Okay, provider directory updates. One of the things we hear from members and sometimes from providers is that the provider directories are not always up to date. And we hear stories from members about, they start to go through the provider directory and they call the first 5 names and, 2 of the phone numbers don't work. 2 of the practices don't consider themselves participating anymore, and the 5th one is not taking new patients. And this gets very frustrating for members. And so Maryland has laws about updating provider directories, and you should definitely respond if you get a request to confirm any of your provider listing information. But there is also a federal law that is going to take effect in 2022. Next slide, please. And this is part of the No Surprises Act that was part of the Consolidated Appropriations Act from the end of last year. And so healthcare providers and facilities will need to have processes in place to ensure that they are updating information with the carriers when beginning a network agreement, terminating a network agreement, or there is some other material change. And if you have not heard about the No Surprises Act, I really urge you to start looking into it because there are other provisions that will impact providers. But this is the piece of it that is relevant to what we're talking about today. Next slide, please. Okay, so facilities. So facilities, as we mentioned, are not under the definition of a provider in section 15112. And a facility is usually credentialed to provide facility services. And then individual practitioners who provide services in the facility sometimes bill separately and sometimes are part of the staff of the facility and don't bill separately. And some of these things will also be impacted by the No Surprises Act. So next slide, please. Okay, the MIA contact information is here. And the number 468-2244 will take you to the Life and Health Complaints Unit. And our website is there. We have added a providers page to our website. We also have a consumer complaint portal that can be used by healthcare providers in filing complaints with the MIA. And do we have another slide or are we at the end? Okay. So I am happy to take questions. Okay, it looks like the question about a delegation agreement for the state of Maryland, is that about Medicaid? Because Medicaid would be, yes. Medicaid, parts of 15.112 apply to Medicaid MCOs. But Medicaid is its own world for some of this. And I'm afraid I can't really speak to how they do credentialing, if it's directly with Medicaid or with Optum. And then I see something, okay. Again, Medicaid, I cannot speak to how outpatient mental health clinics, whether the practitioners would individually contract. That would be a Medicaid issue that I'm not able to talk about. Medicaid is under the Maryland Department of Health. Okay, are there any other questions? Okay. So provider panels for mental health practitioners. Carriers are required to have an adequate provider network. And we have a set of regulations that we are in the process of reviewing and revising about what an adequate network means. However, there is no set time limit on how long a carrier can keep a panel closed to new providers if they have an adequate network. Okay, let's see, a question about how to avoid carriers credentialing individual providers versus group credentialing. And that's going to be probably beyond the scope of what we have in a law, maybe an individual carrier's preferences, but it should be something the law contemplates that there are going to be some group practices. But as we talked about, individual practitioners within a group practice may also have to be credentialed. The next question is substance abuse treatment part of mental health? Yes. We interpret it as being part of mental health. In some cases, in the other laws, we may separate them for considering some things, but when I use the term mental health, I'm including substance use disorder providers. Okay, CAQH being a universal application. Will that apply to all clinicians? When I have looked at it, it includes many types of clinicians other than physicians. I do not know offhand which specific practitioners it includes. Okay, and someone hopefully provided an answer about Medicaid enrollment, so thank you. Related to the timeframes, can carriers send credentialing notices electronically? In general, yes. We generally interpret written notice to include written notice that is transmitted electronically. You know, if the company has opt-in or opt-out notices, I think we would generally say that we would want an opt-in to notices, but I'd have to look further into that. But as a rule, we do see we see complaints where there have been a lot of communications by email on both sides, and we would certainly in that case say that the notices can be provided by email when the parties are clearly communicating by email. but it does have to be in writing. Any other questions?
Not seeing any other questions.
I'm
Mary.
not seeing any more either.
One just popped up.
Yep. Okay, network adequacy standards. That is something that we are working on. We do have network adequacy standards in our regulations. We are looking at revising the regulations. But we do have standards in place now. So the question is, if a provider is credentialed by another employer and they come to us, all we need to do is send a letter with the 4 items listed. If the practitioner is credentialed with the carrier and they come to a new employer, then yes, that's the statute says that that's the notice to give and the carrier should accept that. I should note that this is all for insurance that is regulated by Maryland, but okay. Can a practitioner be credentialed with a carrier as both a sole proprietor and rendering provider? I'm not quite sure what that means. A practitioner could be credentialed with a solo practice and also as part of a group practice, because that could be something where you have the kind of separate office that I talked about, and they're not part of the group practice there, but in that case, they are participating. Okay, how are we enforcing network adequacy standards? Well, this is not a webinar about network adequacy, but we do have the network adequacy executive summaries from the carriers on our website. You can review those, and the regulations are also publicly available. And if you have specific questions, we're happy to answer those at another time. Does the No Surprises Act apply to all insurance companies or just commercial plans? I believe that Medicaid and Medicare, because they have their own rules around balance billing, are separate. But it will apply to commercial plans and to self-funded plans by employers. And so self-funded plans are plans where an employer may use a company like Aetna or CareFirst for a provider network and to process claims, but ultimately the employer is responsible for putting up the money to pay the claims. And so the insurance companies are not assuming risk, is the technical term in the insurance business. And the No Surprises Act will apply to all those types of plans, even though state law does not. So it will be broad reaching, but not to Medicare or Medicaid. Okay, is there anything else?
Okay, I'm not seeing any other questions.
Well, thank you for everyone or thank you to everyone who participated. We appreciate seeing your questions and we appreciate hearing from you later.
Thanks, Mary. As usual, you did a wonderful job. Thank you, as Mary said, to everybody who participated. Please let us have your feedback. We want to be in a state of continuous improvement. So if there are things that we could do a little bit differently or a little bit better or different formats, please let us know. But hopefully you found today's session very valuable. I know I did. So thanks, Mary. I guess we'll call that a wrap, guys.